I sat on my porch one Tuesday afternoon in March, counting vehicles. 2 p.m. to 3 p.m., 1 hour. 47 vehicles drove past my property on Thornton Road, my private road, the one my grandfather built in 1923, 1.2 miles of gravel from the highway to my estate. Quiet for decades, until 2012, when the developer building Riverside Heights subdivision started using it without permission. I'd told him no, in writing. He used it anyway. 12 years later, 340 homes were using my road, 600 vehicles per day. The road was deteriorating, potholes forming, dust clouds in summer. I was paying for all the maintenance. The HOA president, Vanessa Whitmore, offered me $5,000 for a permanent easement. $5,000 for 340 homes using my road 600 times daily. When I refused, she sent 4 security guards to cut my gate lock with bolt cutters. I called the sheriff. All 4 were arrested for trespassing. Vanessa sued me for $40 million, said the road was public, said I couldn't block community access. I've been a civil rights attorney for 38 years. I knew property law. By the time the judge ruled that my road was private property and awarded me $350,000 in damages, Vanessa had lost everything. But let me start from the beginning. Before we dive into, I'd love to know where you're listening from today. And don't forget to hit the like and subscribe buttons for more interesting stories just like this. I first noticed the traffic increase in March 2024. I'd lived on the Thornton estate for 19 years, inherited it from my grandparents in 2005. And for most of that time, Thornton Road had been quiet. My private road, the one my grandfather built in 1923, when he purchased these 80 acres and constructed the manor house. 1.2 miles from the main highway to my front gate, gravel and packed earth, lined with oak trees my grandmother planted in the 1950s. For decades, it had been just family traffic. Then, starting in 2012, the developer who built Riverside Heights, the luxury subdivision that now surrounded my property on 3 sides, started using the last half mile of my road as access to their development. I'd told them no, in writing, multiple times. They used it anyway, but back then, it was maybe 50 vehicles a day. Annoying, but not worth a legal fight while the HOA was still being built. Now, 12 years later, Riverside Heights was complete, 340 homes, and every single one of them was using my road. I sat on my front porch one Tuesday afternoon in early March, counting vehicles. In 1 hour, 2 p.m. to 3 p.m., I counted 47 vehicles driving past my property on Thornton Road. 47 vehicles in 1 hour. I did the math. If that rate held steady across morning and evening rush hours, plus midday traffic, I was looking at 600 plus vehicles per day using my private road. 600 vehicles. On a road built for one family's use. The road was deteriorating, potholes forming from the constant traffic, dust clouds in summer, mud ruts in spring, and I was paying for all the maintenance. I called my attorney, David Ross. I'd worked with him on property issues before. He specialized in land rights and easement law. David, I need to talk about Thornton Road. The HOA traffic is out of control. How bad? 600 vehicles a day. The road's falling apart, and I'm getting no compensation, no maintenance help, nothing. Did you ever grant them an easement? No, never. The developer asked in 2012. I refused in writing. They used the road anyway. So they've been trespassing for 12 years? Correct. David was quiet for a moment. Maggie, you know what this means. If they've been using it openly for 12 years, they might try to claim prescriptive easement. Colorado requires 18 years for prescriptive easement. They're only at 12. True, but they'll argue they're close enough, or that use started earlier than 2012. You need to act now before they hit that 18-year mark. What do you recommend? Post the road. Make it crystal clear it's private property. Send a formal cease and desist to the HOA. And if they don't stop using it, you have the right to gate it. Gate my own road? It's your property. You can control access however you want. I thanked David and hung up. The next day, I drove to a sign shop in town and ordered 6 large signs. Private road. No trespassing. Thornton property. Violators will be prosecuted. Heavy-duty metal signs. Professional. Unambiguous. I installed them along Thornton Road on March 15th, 2024. 2 at the highway entrance, 2 at the midpoint, 2 near my estate gate. Impossible to miss. For 3 days, nothing changed. The HOA traffic continued exactly as before. 600 vehicles a day, driving past my signs like they didn't exist. On March 18th, I sent a formal letter to the Riverside Heights HOA Board. Dear Riverside Heights HOA Board, Thornton Road is private property, owned entirely by Margaret Thornton. The road was constructed in 1923 and has been maintained by the Thornton family for 101 years. No easement, express or implied, has ever been granted to Riverside Heights HOA or its residents. Your residents are currently using Thornton Road without permission. This constitutes trespassing. I am formally demanding that all unauthorized use cease immediately. If HOA residents continue using Thornton Road after March 25, 2024, I will take legal action, including, but not limited to, gating the road and seeking damages for trespass. Respectfully, Margaret Thornton. I sent it certified mail to the HOA's registered address. On March 22nd, someone knocked on my door. I opened it to find a woman in her mid-40s standing on my porch. Blonde hair, expensive athleisure outfit, oversized sunglasses pushed up on her head. She had the confident posture of someone used to getting her way. Margaret Thornton? That's me. I'm Vanessa Whitmore, president of the Riverside Heights HOA. We need to talk about the road. I stepped aside. Come in. She walked into my foyer, a beautiful space with original 1920s woodwork and a chandelier my grandmother had imported from France, and looked around with barely concealed judgment. Interesting place, very historic. It's 101 years old. My grandfather built it. Right, about the road. Vanessa pulled a folder from her designer handbag. I received your letter. I have to say it was quite surprising. Thornton Road has been the main access route for Riverside Heights since the community was built. Our residents rely on it. Suddenly claiming it's private and threatening to block access is problematic. I stayed calm. Thornton Road has always been private. I've never claimed otherwise. Your developer knew it was private in 2012. I told him explicitly. That was 12 years ago, the previous developer. I'm dealing with current realities. The reality is that Thornton Road serves our community. 340 homes depend on it for access. Your homes have access via county roads. Thornton Road is a shortcut, not a necessity. Vanessa's expression hardened slightly. The county road route adds 12 miles. That's not reasonable. What's not reasonable is using someone else's private road without permission or compensation for 12 years. She opened her folder and pulled out a document. Mrs. Thornton, I'm prepared to offer you a formal easement agreement. The HOA will grant you $5,000 as a one-time payment in exchange for permanent access rights to Thornton Road. I almost laughed. $5,000? For permanent access for 340 homes using my road 600 times a day? It's a generous offer, considering the road already serves a public purpose. The road serves no public purpose. It's private property. And $5,000 doesn't even cover 1 year of the maintenance costs I've been shouldering. Vanessa put the document back in her folder. Mrs. Thornton, let me be direct. Riverside Heights has been using this road for over a decade. That establishes prescriptive easement. Legally, you can't block us now. I'd been a civil rights attorney for 38 years before I retired. I knew property law, and I knew Vanessa was bluffing. Colorado law requires 18 years of continuous, open, and hostile use to establish prescriptive easement. You're at 12 years. You're 6 years short. We can argue that use began earlier. It didn't. The development started in 2012. I have documentation. Fine. But hostile use means without permission. Our residents have been using the road openly, assuming it was available for community access. That's hostile. No, it's not. Hostile use means the owner objected, and the user continued anyway. Your developer asked my permission in 2012. I denied it in writing. That means he knew it was private property, and I objected. Any use after that is knowing trespass, not hostile prescriptive use. Vanessa's jaw tightened. You're splitting legal hairs. I'm stating the law. You have no prescriptive easement. You have no express easement. You have no implied easement. What you have is 12 years of trespassing on private property. She stood up. This isn't over, Mrs. Thornton. The HOA has resources. We have 340 homeowners who will fight for their access rights. If you try to block this road, we will take you to court. You're welcome to try, but the law is on my side. Vanessa walked to the door, then turned back. You're being unreasonable. This road serves the community. Blocking it will hurt hundreds of families. Those families chose to buy homes in a development with inadequate infrastructure. That's not my problem. The road is mine. If you want to use it, you negotiate fairly and compensate me appropriately. If you don't, you stop using it. We'll see what a judge says. She left. I stood in my foyer for a moment, then called David. Vanessa Whitmore just left my house, HOA president. She offered me $5,000 for a permanent easement and threatened to sue when I refused. $5,000 for 340 homes using your road daily? That was my reaction. She's posturing. She knows she doesn't have a legal case, so she's trying to bully you. What's my next step? Wait, see if she actually sues or if she backs down. In the meantime, keep documenting the traffic. Take photos, keep records. If this goes to court, we'll need evidence of the trespass and the damage to your property. For the next week, I monitored the road. The traffic didn't decrease. If anything, it increased. I started recognizing the same vehicles: morning commuters, afternoon school pickups, evening returns, all of them driving on my private road like they owned it. On March 29th, I received a letter from an attorney named Patricia Vance, representing Riverside Heights HOA. Dear Ms. Thornton, this office represents Riverside Heights HOA. We are writing regarding your recent threats to restrict access to Thornton Road. Our clients have utilized this road as the primary access route to their community for over 10 years, establishing clear prescriptive rights. Any attempt to block or restrict access will be met with immediate legal action. We strongly encourage you to reconsider your position and work cooperatively with the HOA to formalize an access agreement. Continued obstruction will result in litigation that will be costly and time-consuming for all parties. Sincerely, Patricia Vance, Esquire. I forwarded the letter to David. He called me 20 minutes later. They're bluffing. Everything in that letter is wrong. No prescriptive rights, no legal standing, just threats. So what do? You have two choices. You can respond through me, laying out why they're wrong, or you can take action and gate the road. If I gate it, what happens? They'll probably sue for access, but you'll win. The law is absolutely clear. It's your private road, no easement exists, and they have alternative access via county roads. You'd win, and they'd have to pay your legal fees. I thought about my grandfather building this road 101 years ago, about my grandmother planting oak trees along it, about 19 years of watching developers and HOAs slowly encroach on my property, asking for inches and taking miles. I'm gating it. When? This week. On April 3rd, 2024, I hired a contractor to install a gate at the point where Thornton Road crossed from the public right-of-way onto my private property. A solid steel gate, 12 feet wide, automated, controlled by keypad and remote, and a large sign. Private property, authorized access only. Trespassers will be prosecuted. The gate was installed in one day. That evening, as I locked it for the first time, I thought about Vanessa Whitmore's threat. We'll take you to court. Good, let them. Because I'd spent 38 years defending people's civil rights in court, and now I was defending my own property rights. Vanessa thought she could bully a 67-year-old woman into surrendering her private road. She was about to learn that this 67-year-old woman was a retired civil rights attorney who'd fought bigger battles than a HOA dispute. And I'd never lost a case I knew I was right about. Vanessa wanted a fight. She was going to get one. The gate went up on April 3rd, 2024. By April 4th, my phone was ringing non-stop. I didn't answer. I knew who was calling. Angry HOA residents who'd driven to the gate expecting their usual route and found it locked. I let the calls go to voicemail. The messages were predictable. Mrs. Thornton, this is ridiculous. I have to get to work. Open the gate. You can't just block a public road. This is illegal. My kids need to get to school. What are we supposed to do? I'm calling my attorney. You'll be hearing from us. I deleted them all. The gate stayed locked. On April 5th, I drove down to the gate around 8 a.m., prime commute time, to see the impact. A line of vehicles was backed up on the county road at the intersection with Thornton Road. 15 cars, waiting, honking, drivers getting out to look at the gate. I watched from a distance as they realized the gate wasn't opening. One by one, they turned around and headed back toward the county road detour. The detour added 12 miles to their trip. Instead of turning onto Thornton Road and driving 1.2 miles straight to Riverside Heights, they now had to continue south on the county road for 6 miles, turn east for 4 miles, then north for 2 miles to reach the back entrance of the subdivision. Inconvenient? Yes. Impossible? No. The HOA had alternative access. They just didn't want to use it. That afternoon, Vanessa called me directly. I answered. "Mrs. Thornton, what do you think you're doing?" "Protecting my property. You've locked the gate. Our residents can't access their homes." "Your residents can access their homes via the county road route. It's 12 miles longer, but it's perfectly functional." 12 miles. That adds 30 minutes to every trip. People have jobs, children, responsibilities. Then they should have thought about that before buying homes in a development with inadequate infrastructure. "You're being spiteful." "I'm exercising my property rights. This is my road. You're not paying for it. You're not maintaining it. You don't have an easement. You're trespassing. We've used this road for 12 years. Without permission, that's called trespassing." Vanessa's voice went cold. "You're going to regret this." "Is that a threat?" "It's a promise. The HOA board is meeting tonight. We will take action." She hung up. I sat on my porch, sipping tea, and waited to see what action looked like. The next morning, April 6th, I got my answer. At 7:30 a.m., I was in my kitchen making breakfast when I heard vehicles approaching on Thornton Road. I looked out the window and saw 2 white SUVs with Riverside Heights security emblazoned on the sides pulling up to my gate. 4 men got out, all wearing matching uniforms, black polo shirts with courtesy officer patches, tactical pants, utility belts with radios and flashlights, private security guards, the HOA's courtesy officers. I watched as they approached the gate, examined the lock, and started talking on their radios. Then one of them pulled out bolt cutters. I grabbed my phone and walked outside. By the time I reached the gate, about 200 yards from my house, 2 of the officers were trying to cut through the chain securing the gate lock. "Excuse me," I called out. "What do you think you're doing?" The lead officer, a man in his 40s with a shaved head and an overly authoritative posture, turned to face me. "Ma'am, we're Riverside Heights courtesy officers. We've been authorized by the HOA board to open this gate and restore community access. This is private property. You're trespassing. Leave immediately." "Ma'am, the HOA board has determined that this gate constitutes an illegal obstruction of community access. We have authority to remove the obstruction." I stayed calm. "You have no authority here. This property is not part of Riverside Heights HOA. This road is private. The gate is lawful. You are trespassing." The second officer stepped forward. He was younger, early 30s, trying to look intimidating. "Ma'am, we're not leaving until the gate is open. The HOA board has given us clear instructions. Open the gate now, or we'll open it ourselves." "The HOA board has no jurisdiction over my property. I am not a member of your HOA. This road was built in 1923, 50 years before your HOA existed. You have no legal right to be here." The lead officer crossed his arms. "Ma'am, we have residents who need to access their homes. This road is the primary access route for 340 families. Blocking it is unreasonable and possibly illegal. Those families have alternative access via county roads. This road is my private property. I've blocked it because your HOA has been trespassing for 12 years without permission or compensation. We're not debating this with you. Open the gate or we'll remove it." I pulled out my phone. "I'm calling the sheriff. You are trespassing on private property and threatening to damage my property. If you don't leave immediately, you will be arrested." The third officer, older, maybe 50, spoke up. "Ma'am, we're courtesy officers. We have legal authority to enforce HOA rules. Not on property that isn't in the HOA. This is my land. Your authority ends at my property line. You are currently 200 yards inside my property line. That's trespassing. The lead officer sneered. You can call whoever you want. We're not leaving until this gate is open. I dialed 911. Douglas County Sheriff, what's your emergency? This is Margaret Thornton at 4820 Thornton Road. I have 4 men on my property attempting to force open a gate and damage my property. They're refusing to leave. Are they armed? They have utility belts with equipment. I don't see firearms. Units are on the way. Stay on the line. I stayed on the phone, standing 15 feet from the gate, watching the 4 courtesy officers. The lead officer spoke into his radio. Control, this is Unit 3. Property owner is uncooperative and has called law enforcement, requesting guidance. I couldn't hear the response, but the officer's expression suggested he wasn't getting the guidance he wanted. Copy that, he said into the radio. Then to me, ma'am, the HOA board is aware of the situation. We've been instructed to wait for law enforcement and clarify jurisdiction. Good, because the sheriff will clarify that you're trespassing. We stood in tense silence for 8 minutes. Then I heard sirens. 2 Douglas County Sheriff's vehicles pulled up behind the courtesy officers' SUVs. 4 deputies got out. The lead deputy, a woman in her 40s with sergeant stripes, approached. I'm Sergeant Linda Hayes. Who called this in? I raised my hand. I did. Margaret Thornton. This is my property. These 4 men are trespassing and attempted to force open my gate with bolt cutters. Sergeant Hayes turned to the courtesy officers. Is that accurate? The lead officer straightened up. Sergeant, we're Riverside Heights HOA courtesy officers. We were sent here to open this gate, which is blocking access to 340 homes in our community. The gate is an illegal obstruction. Whose property is this? Sergeant Hayes interrupted. This is Thornton Road. It's been the community access route. I didn't ask about access. I asked whose property this is. I stepped forward. It's my property, Sergeant. 80 acres including this entire road. I have the deed, survey, and tax records inside my house if you'd like to see them. And these men are here without your permission? Correct. I told them to leave. They refused. One of them was attempting to cut the lock on my gate when I arrived. Sergeant Hayes turned back to the courtesy officers. You were attempting to damage private property? The lead officer hesitated. We were instructed by the HOA board. The HOA board has no authority to authorize trespassing or property damage on land that isn't part of the HOA. Is this property part of Riverside Heights HOA? Well, no, but the road serves. Yes or no? Is this property part of the HOA? No. Then you're trespassing. All 4 of you. Put your hands behind your back. The lead officer's eyes went wide. Sergeant, we're courtesy officers. We have legal authority. You have no authority here. You're trespassing on private property. You refused to leave when asked, and you attempted to damage private property. You're under arrest. The 4 courtesy officers were handcuffed within 2 minutes. As they were being loaded into the sheriff's vehicles, the lead officer looked at me with pure fury. This isn't over. The HOA will fight this. I looked at Sergeant Hayes. I want to press full charges. Trespassing, attempted property damage, and refusing to leave when ordered. Understood. We'll need you to come to the station and give a full statement. I'll be there this afternoon. The sheriff's vehicles drove away with the 4 courtesy officers in custody. I stood at my gate, looking at the bolt cutters they'd left on the ground. They'd tried to force my gate open, on the orders of the HOA board. This wasn't just trespassing anymore. This was coordinated, aggressive action to violate my property rights. Vanessa had escalated, and she'd just made a massive mistake. I called David Ross. David, the HOA just sent 4 security guards to force open my gate. They tried to cut the lock. Sheriff arrested all 4 for trespassing and attempted property damage. There was a long pause. Maggie, they sent people to physically force open your gate? Yes. They called themselves courtesy officers. Said they had authority from the HOA board. That's criminal. The HOA board authorized criminal trespass and property damage. You can sue them personally, not just the HOA. I want more than a lawsuit. I want this HOA to understand that they cannot bully me into surrendering my property rights. What are my options? Keep the gate locked. Press full criminal charges against the 4 guards, and potentially against Vanessa and the board members who authorized this. File a civil suit for harassment, trespassing, and attempted property damage. And prepare for them to sue you, because they will. Let them sue. I have 18 years of legal experience, and every property document proving this road is mine. Then we'll be ready. I drove to the sheriff's station that afternoon and filed a full report. Sergeant Hayes took my statement and confirmed the 4 courtesy officers were being charged with criminal trespass and attempted criminal mischief. "Do you know who sent them?" she asked. "The HOA board, specifically the president, Vanessa Whitmore. We'll be contacting her. If she authorized this, she could face charges for conspiracy to commit criminal trespass." Good. That evening, I sat on my porch and watched the sunset over my 80 acres. The gate was locked. 4 HOA security guards were in custody, and 340 homes were taking a 12-mile detour. Vanessa Whitmore thought she could intimidate me. She was wrong. The cease and desist letter arrived on April 10th, 2024. I was sitting on my porch reading when the courier delivered it. Certified mail, signature required, marked, urgent legal notice. I signed for it, opened the envelope, and read, "Cease and desist demand to Margaret Thornton, from Patricia Vance, attorney at law, on behalf of Riverside Heights HOA RE, illegal obstruction of community access road. Ms. Thornton, this office represents Riverside Heights Homeowners Association. You are hereby ordered to immediately remove the gate you have unlawfully installed on Thornton Road, a public access road serving 340 families in the Riverside Heights community. Thornton Road has functioned as the primary access route for Riverside Heights since 2012. Your unilateral decision to gate this road violates 1. Community easement rights established through continuous use. 2. Public necessity doctrine requiring reasonable access to residential communities. 3. Colorado statutes prohibiting obstruction of established access routes. Furthermore, your actions have resulted in the arrest of 4 HOA courtesy officers, who were acting within their lawful authority to restore community access. The HOA intends to pursue all legal remedies, including, but not limited to, criminal charges against you for false imprisonment and civil damages for harassment. You have 72 hours from receipt of this letter to remove the gate and restore full access to Thornton Road. Failure to comply will result in immediate legal action seeking injunctive relief and substantial damages. Sincerely, Patricia Vance, Esquire. I read it twice, then called David Ross. "David, I just received a cease and desist from the HOA's attorney. It's threatening legal action if I don't remove the gate within 72 hours. "What are the grounds?" "Community easement rights, public necessity doctrine, and obstruction of established access routes. Also threatening criminal charges for false imprisonment of the courtesy officers." David laughed. A short, sharp laugh. "False imprisonment? They trespassed on your property and were arrested by law enforcement. That's not false imprisonment. That's consequences." "What about the other claims? Community easement, public necessity?" "All nonsense. There's no community easement. We'll prove that. Public necessity doesn't apply because they have alternative access. And Colorado has no statute prohibiting property owners from gating their own private roads. This letter is 90% bluff. What's the 10% that isn't bluff? They will sue, probably for injunctive relief, trying to force you to open the gate while the case proceeds. We need to be ready with airtight documentation proving the road is yours and no easement exists. I have everything: original deed, road construction records, surveys, tax records going back to 1921. Good. Bring it all to my office tomorrow. We'll prepare a response that destroys every claim in that letter. The next day, I arrived at David's office with 2 boxes of documents. Original 1921 deed showing my grandfather's purchase of 80 acres. 1923 construction records for Thornton Road, including engineering plans and contractor invoices showing my grandfather paid for the entire project. Property surveys from 1923, 1965, 1989, and 2009, all showing Thornton Road entirely within my property boundaries. Tax records from 1921 to 2024, showing continuous Thornton family ownership and tax payments. And the critical 2012 correspondence. In May 2012, when the Riverside Heights developer, Westbrook Development LLC, first approached me about using Thornton Road, I'd responded in writing. David read the letter I'd sent. Dear Mr. Westbrook, thank you for your inquiry regarding use of Thornton Road as access to your planned development. I must respectfully decline. Thornton Road is private property, built and maintained by my family since 1923. Granting an easement for 340 homes would dramatically increase traffic, cause significant wear and maintenance costs, and compromise the privacy my family has enjoyed for 91 years. I understand this may complicate your development plans, but I cannot authorize use of my private road for large-scale residential traffic. I recommend you construct a complete internal road system connecting directly to county roads. Best regards, Margaret Thornton. David looked up. This is perfect. You explicitly denied permission in 2012. That means any use after this date was knowing trespass, not good faith reliance on an assumed right. The developer used it anyway. The HOA has been using it for 12 years, which is trespassing, not prescriptive easement. Prescriptive rights require hostile use, meaning the user doesn't ask permission and the owner doesn't grant it. But if the user asks permission and the owner explicitly denies it, any subsequent use is just trespass. They can't claim prescriptive rights because they acknowledged your ownership by asking. So their prescriptive easement claim fails? Completely. And even if it didn't, Colorado requires 18 years of continuous hostile use. They're only at 12. They're 6 years short. David spent the next 3 hours drafting a response. The letter he sent to Patricia Vance on April 12, 2024 was devastating. Dear Ms. Vance, this office represents Margaret Thornton in response to your cease and desist letter dated April 9, 2024. Your claims are without merit, and your threats of legal action are baseless. We address each claim below. 1. Community easement rights. No easement, express or implied, exists for Thornton Road. The road was constructed in 1923 by Ms. Thornton's grandfather on his private property at his sole expense. See attached construction records. The road has been maintained exclusively by the Thornton family for 101 years. No easement was ever granted to Riverside Heights HOA or its predecessor developers. 2. Prescriptive easement. Your client cannot claim prescriptive easement. Colorado requires 18 years of continuous, open, and hostile use. CRS Section 38, 41, 101. Your client's use began in 2012, only 12 years ago. Furthermore, hostile use requires that the user did not seek permission. Your client's developer explicitly sought permission in 2012, which Ms. Thornton denied in writing. See attached May 2012 letter. Any use after that denial constitutes knowing trespass, not hostile prescriptive use. Sun, public necessity doctrine. Public necessity requires that no reasonable alternative access exists. Riverside Heights has full access via county roads. The route is 12 miles longer, but it is functional and has been used by residents since April 3rd, when Ms. Thornton gated her private road. Inconvenience is not the same as necessity. 4. Obstruction of established access routes. Colorado has no statute prohibiting private property owners from gating roads on their own land. Ms. Thornton owns Thornton Road in fee simple, see attached deed and surveys. She has absolute right to control access. 5. Criminal charges for false imprisonment. This threat is frivolous. 4 individuals employed by your client trespassed on Ms. Thornton's property, refused to leave when ordered, and attempted to damage her property with bolt cutters. They were arrested by Douglas County Sheriff's deputies and charged with criminal trespass and attempted criminal mischief. Ms. Thornton had no role in their arrest beyond calling law enforcement to report a crime in progress. Threatening her with criminal charges for reporting a crime is itself potentially actionable. Conclusion: Ms. Thornton will not remove the gate. Thornton Road is private property. Your client has no legal right to use it. If your client wishes to negotiate an easement agreement with appropriate compensation and terms, Ms. Thornton is willing to discuss such an arrangement through counsel. Otherwise, the gate remains closed. If your client files suit seeking injunctive relief or damages, we will vigorously defend and counterclaim for 12 years of trespassing damages, Cost of road maintenance improperly borne by Ms. Thornton. Harassment and intentional infliction of emotional distress. Malicious prosecution, if frivolous criminal charges are filed. Attorney's fees and costs. We have attached 103 years of property records documenting Ms. Thornton's ownership. We recommend you review them carefully before proceeding. Respectfully, David Ross, Attorney at Law. The letter was accompanied by 85 pages of attachments, deeds, surveys, tax records, construction documents, the 2012 denial letter, everything. David sent it certified mail and emailed a copy to Patricia Vance. She called him the next day. David put her on speakerphone so I could listen. Mr. Ross, I've reviewed the documents you sent. And? Your client's ownership of the road is well documented. It's not well documented. It's absolute. She owns every inch of that road, has since 1923. I understand. But Mr. Ross, my client has 340 families who have been using that road for 12 years. They've built their lives around that access. Cutting it off causes enormous hardship. Hardship doesn't create legal rights, Ms. Vance. Your client trespassed for 12 years. Now they're facing the consequences. What would it take for Ms. Thornton to consider reopening the road? David looked at me. I nodded. Ms. Thornton is willing to discuss a formal easement agreement, but it would require fair compensation, reflecting 12 years of past use, ongoing annual fees, a maintenance agreement requiring the HOA to repair and maintain the road, and liability insurance protecting Ms. Thornton from any accidents or incidents on the road. What kind of compensation are we talking about? Given that 340 homes have been using the road generating approximately 600 vehicle trips per day, with maintenance costs averaging $8,000 annually, plus wear and tear, plus loss of privacy and exclusive use, we'd be starting negotiations at $250,000 for past damages, plus $15,000 annually going forward. There was a long pause. Mr. Ross, the HOA doesn't have that kind of money in reserves. Then your client should consider special assessments, or they can continue using the county road detour. Those are the options. The county road adds 30 minutes to every trip. Property values are already dropping because of the access issue. Homeowners are furious. Ms. Vance, your client created this problem by building a development dependent on someone else's private road without securing an easement. That was poor planning by the developer and poor oversight by the HOA. Ms. Thornton is not obligated to solve your client's infrastructure problems for free. Another pause. I'll discuss this with the HOA board, but Mr. Ross, they're very angry. The board president, Vanessa Whitmore, she's not going to accept this quietly. Mrs. Whitmore sent 4 men to cut open Mrs. Thornton's gate. Those men are facing criminal charges. If Ms. Whitmore wants to escalate further, she's welcome to try. But she should know that every escalation will be documented, and Ms. Thornton will seek full legal remedies. Patricia Vance hung up. David turned to me. She knows they don't have a case. She's trying to find a way to get the board to negotiate. But Vanessa won't negotiate. Probably not, which means they'll sue. How long until they file? Could be days, could be weeks, but they'll file. Vanessa sounds like someone who can't admit she's wrong. He was right. On April 18, 2024, 6 days later, I was served with a lawsuit. Riverside Heights Homeowners Association versus Margaret Thornton. Complaint for injunctive relief and declaratory judgment. The HOA was suing me to force the gate open, and they were asking the court to declare that they had a legal right to use Thornton Road. David called me when he received his copy of the complaint. Maggie, they filed. They're seeking an emergency injunction to force you to open the gate while the case proceeds. Hearing is scheduled for May 2nd. Can they win the injunction? Not if the judge reviews the evidence. But we need to be prepared. This is going to be a fight. I looked out at my property, at the oak trees lining Thornton Road, at the manor house my grandfather built 101 years ago. Vanessa Whitmore thought she could take my road through litigation. She was about to learn that I'd spent 38 years in courtrooms, and I'd never lost a case where the law was on my side. This wouldn't be the first. The emergency injunction hearing was scheduled for May 2nd, 2024, at 9 a.m. in Douglas County District Court. David and I arrived at 8:30 a.m. He carried 2 large binders of evidence, deeds, surveys, correspondence, photographs, tax records, everything we needed to prove that Thornton Road was my private property, and the HOA had no legal right to use it. We sat at the defendant's table and waited. At 8:45 a.m., Patricia Vance arrived with Vanessa Whitmore and 3 HOA board members. Vanessa was dressed in an expensive navy suit, her expression confident. She glanced at me once with barely concealed contempt. I stayed calm. I'd been in hundreds of courtrooms over my 38-year career. This was just another hearing. Judge Catherine Brennan took the bench at 9 a.m. sharp. Good morning. This is the matter of Riverside Heights Homeowners Association versus Margaret Thornton. We're here on the plaintiff's motion for a preliminary injunction requiring the defendant to remove a gate blocking access to Thornton Road. Ms. Vance, you may proceed. Patricia Vance stood. Thank you, Your Honor. The plaintiff, Riverside Heights HOA, represents 340 families who have relied on Thornton Road as their primary access route for 12 years. On April 3rd, the defendant unilaterally installed a gate blocking this access, forcing residents to take a 12-mile detour that adds 30 minutes to every trip. This has caused severe hardship, parents struggling to get children to school, workers arriving late to jobs, emergency vehicles delayed in reaching homes. She pulled up a slide showing a map of the area. As you can see, Thornton Road provides direct access from the highway to Riverside Heights. The alternative route requires residents to travel 12 additional miles on narrow county roads. This is not reasonable. The defendant's gate constitutes an unlawful obstruction of access that serves an entire community. Judge Brennan looked at the map. Ms. Vance, does an alternative route exist? Technically, yes, but it's completely impractical. 12 miles longer, poorly maintained roads. It effectively cuts off 340 families from reasonable access to their homes. But it is functional. Residents can reach their homes via the alternative route? Patricia hesitated. Yes, but at significant inconvenience. I understand. Continue. Patricia clicked to the next slide, a timeline showing HOA use of the road since 2012. Your Honor, Riverside Heights residents have used Thornton Road continuously and openly for 12 years. This establishes prescriptive easement under Colorado law. The defendant cannot suddenly revoke access that has been relied upon by hundreds of families for over a decade. She paused for effect. We're requesting a preliminary injunction requiring the defendant to remove the gate immediately while this case proceeds. Without it, 340 families will continue suffering daily hardship. The balance of equities strongly favors the plaintiff. Thank you, Ms. Vance. Mr. Ross? David stood, carrying one of the binders. Your Honor, this case is straightforward. Margaret Thornton owns Thornton Road. She has owned it since inheriting the property in 2005. Before that, her family owned it for 84 years. The road was built by her grandfather in 1923 at his sole expense on his private property. He opened the binder and handed copies to the judge and opposing counsel. This is the original 1921 deed showing purchase of 80 acres. This is the 1923 construction record showing that Ms. Thornton's grandfather paid $4,800 to build the road, a substantial sum at the time. These are property surveys from 1923, 1965, 1989, and 2009. All showing that Thornton Road lies entirely within the Thornton property boundaries. And these are tax records from 1921 to 2024, showing continuous Thornton family ownership and payment of property taxes. Judge Brennan reviewed the documents. Mr. Ross, does the HOA dispute that the road is on Miss Thornton's property? They cannot dispute it, Your Honor. The evidence is overwhelming. Then what is the basis for their claim to access? They're claiming two theories. First, easement by necessity, arguing that they need access via Thornton Road because the alternative is too inconvenient. Second, prescriptive easement, arguing that 12 years of use creates a right. And your response? Both theories fail. Easement by necessity requires that no alternative access exists. Colorado law is clear on this point. Inconvenience is not the same as necessity. Riverside Heights has full access via county roads. The route is longer, but it's functional. Emergency vehicles can reach every home. Residents can get to work, school, and everywhere else. They just have to drive 12 extra miles. That doesn't meet the standard for necessity. David pulled out a county road map and handed it to the judge. This shows the alternative route. It's paved county roads in good condition. Yes, it's longer, but it's not impossible or even dangerous. It's just inconvenient. Judge Brennan studied the map. Ms. Vance, Mr. Ross is correct that easement by necessity requires lack of any alternative access, not merely inconvenient access. How do you respond? Patricia stood. Your Honor, while a route technically exists, the added time and distance constitute a de facto denial of reasonable access. 30 minutes added to every trip is not trivial. But it's not impossibility, Judge Brennan interrupted. The standard for easement by necessity is high. It requires that the property be landlocked, with no access whatsoever. That's not the case here. Patricia sat down, looking frustrated. Mr. Ross, what about the prescriptive easement claim? David smiled slightly. That claim fails for 2 reasons, Your Honor. First, Colorado requires 18 years of continuous hostile use to establish prescriptive easement. The HOA's use began in 2012, only 12 years ago. They're 6 years short. And the second reason? Hostile use means the owner objected and the user ignored the objection, thereby adversely possessing the right of access. But in May 2012, the developer who built Riverside Heights, Westbrook Development LLC, explicitly asked Ms. Thornton for permission to use the road. David handed the judge a copy of the 2012 correspondence. This is Ms. Thornton's response. She clearly and unambiguously denied permission. She told the developer that Thornton Road was private and she would not authorize its use for large-scale residential traffic. Judge Brennan read the letter. Ms. Thornton explicitly denied permission in 2012? Yes, Your Honor, which means any use after that date was knowing trespass, not hostile prescriptive use. You cannot claim adverse possession or prescriptive rights when you've asked for permission and been denied. That demonstrates you knew the property wasn't yours, and you were using it without right. Patricia stood quickly. Your Honor, the developer asked permission, but the HOA residents used the road in good faith, believing it was available for community access. Ms. Vance, the legal standard doesn't turn on what individual residents believed. It turns on whether the use was hostile to the owner's rights. If the developer acknowledged Ms. Thornton's ownership by asking permission and she denied it, then any subsequent use by the developer or the HOA that purchased the development is trespass. The prescriptive easement clock never started. Patricia sat back down, her expression tight. Judge Brennan reviewed the documents for several minutes in silence. Then she looked up. I'm denying the preliminary injunction. Vanessa's head snapped up, her mouth opening slightly in shock. The plaintiff has failed to establish likelihood of success on the merits. Easement by necessity does not apply because alternative access exists. The route is longer and less convenient, but it is functional. Inconvenience is insufficient to meet the necessity standard. Patricia started to stand, but Judge Brennan continued. As for prescriptive easement, the plaintiff faces 2 insurmountable problems. First, only 12 years have elapsed, 6 years short of the 18-year requirement. Second, and more importantly, the developer asked Ms. Thornton for permission in 2012, and she denied it. That defeats any claim of hostile use. The use was not adverse, it was knowing trespass. She closed the file. Ms. Thornton owns the road. She has the right to control access to her private property. The plaintiff's residents may find the alternative route inconvenient, but that does not create a legal right to use someone else's private road. Preliminary injunction denied. The gate may remain in place pending resolution of the underlying case. Patricia stood. Your Honor, may we request an expedited trial date? The hardship to 340 families. Ms. Vance, I've just ruled that your client has alternative access. There is no emergency. The case will proceed on the normal docket. Trial is set for September 16th. Anything else? David stood. Your Honor, I'd like to file a counterclaim on behalf of Ms. Thornton for 12 years of trespassing damages, cost of road maintenance, harassment, and intentional infliction of emotional distress related to the April 6th incident where HOA security guards attempted to force open Ms. Thornton's gate. File within 30 days. Thank you, Your Honor. Judge Brennan banged the gavel. We're adjourned. I walked out of the courtroom with David. Behind us, I could hear Vanessa's voice rising. This is insane. We can't wait until September. Our residents are furious. Patricia's voice, quieter. Vanessa, the judge ruled. We lost the injunction. The gate stays closed until trial. Then we settle, offer her whatever she wants. She wants $250,000, plus annual fees. That's extortion. It's her property. She can charge whatever she wants. We left the courthouse and stood in the parking lot. David looked at me. You won the injunction hearing. The gate stays closed, but Vanessa's not going to give up. She'll fight this all the way to trial. Then we'll beat her at trial too. The HOA is going to rack up massive legal fees. This could cost them $100,000 or more by the time we're done. Plus your counterclaim for damages. They're looking at $300,000 to $400,000 in total costs if they lose at trial. That's their problem. They should have negotiated when they had the chance. Over the next 4 months, the case moved slowly through discovery. Patricia Vance sent interrogatories and document requests. We responded with thousands of pages of evidence, every property document, every maintenance record, every piece of correspondence with the developer and HOA. We deposed Vanessa in July. She was hostile and defensive, insisting that the HOA had every right to use the road and that I was being unreasonably obstinate. David asked her directly, "Ms. Whitmore, do you have any evidence, any document, any agreement, any record, showing that Ms. Thornton ever granted permission for the HOA to use Thornton Road? We've been using it for 12 years. That's our evidence." "That's evidence of trespassing, not permission. Do you have evidence of permission? The road has always been open." "That's not the question. Do you have written permission?" "No." "Do you have oral permission?" "No, but thank you." We also deposed the original developer, Richard Westbrook, who'd built Riverside Heights. He confirmed that he'd asked me for an easement in 2012, and I'd refused. "Why did you use the road after Ms. Thornton refused permission?" David asked. Westbrook shifted uncomfortably. "The alternative route added significant cost to the project. Thornton Road was right there. We figured she'd come around eventually, or we'd establish prescriptive rights. So you knowingly trespassed, hoping to create legal rights through continued illegal use." "I wouldn't phrase it that way." "How would you phrase it?" "We used a road that was convenient, a road you knew was private and you'd been told you couldn't use." "Yes. Thank you." By September, the case was ready for trial. But on September 10th, 6 days before trial, Patricia Vance called David. "Mr. Ross, the HOA board wants to settle." "What are the terms?" "The HOA will pay Ms. Thornton $150,000 in damages for past use, agree to an annual fee of $10,000, and take responsibility for road maintenance and liability insurance. In exchange, Ms. Thornton grants a permanent easement for HOA access." David looked at me. I shook my head. "Ms. Vance, my client's position hasn't changed. $250,000 for past damages, $15,000 annually, full maintenance responsibility, and $2 million in liability coverage, non-negotiable. The HOA doesn't have $250,000 in reserves. They'd have to special assess every homeowner. That's over $700 per household. That's what happens when an HOA gambles on a lawsuit and loses. We haven't lost yet. We're going to trial. Then we'll see you in court." She hung up. The trial lasted 3 days, September 16th, 17th, and 18th. The HOA called expert witnesses who testified about the community importance of Thornton Road and the unreasonable hardship of the detour. We called property law experts who testified that private property rights are absolute and convenience doesn't create easement rights. On September 18th, Judge Brennan issued her ruling from the bench. The court finds in favor of the defendant, Margaret Thornton, on all counts. Vanessa's face went white. "Ms. Thornton owns Thornton Road. No easement, express, implied, prescriptive, or by necessity, exists. The plaintiff's use of the road for 12 years was trespassing. The plaintiff is ordered to cease all use of Thornton Road immediately." Patricia stood. "Your Honor, if we could request—" "I'm not finished, Ms. Vance. On the defendant's counterclaim, the court finds that the plaintiff's 12 years of unauthorized use caused quantifiable damages. The defendant is awarded $180,000 in compensatory damages for past trespass and road maintenance costs borne solely by the defendant." She looked at her notes. Additionally, the court finds that the April 6th incident, where the plaintiff sent security personnel to force open the defendant's gate, constitutes harassment and intentional infliction of emotional distress. The defendant is awarded an additional $45,000 in damages. Finally, pursuant to Colorado statute allowing prevailing parties in property rights cases to recover attorney's fees, the defendant is awarded $125,000 in reasonable attorney's fees and costs. I did the math quickly. $180,000 plus $45,000 plus $125,000 equals $350,000. The HOA owed me $350,000. Judgment is entered for the defendant. The plaintiff's complaint is dismissed with prejudice. Court is adjourned. David and I walked out of the courtroom. Behind us, I heard Vanessa's voice, shaking with rage. How are we supposed to pay $350,000? We don't have that money. Patricia's voice, weary. Special assessment. Every homeowner will have to pay approximately $1,000. And Vanessa, the board is going to hold you personally responsible for this. You pushed for the lawsuit. You sent those security guards. This is on you. The courthouse doors closed behind us. David turned to me. You won. Complete victory. $350,000 in damages. HOA's access is permanently cut off unless they negotiate on your terms. I looked back at the courthouse. They could have settled months ago for less. They chose to fight. And they lost everything. The gate stayed closed. After the September 18th court ruling, I'd driven down to check on it. Still locked. Still secured. The signs still clearly visible. Private property. Authorized access only. And 340 homes in Riverside Heights were still taking the 12-mile detour every single day. Morning commutes, school runs, grocery trips, doctor appointments. Everything required an extra 25 to 30 minutes because they had to drive south 6 miles, east 4 miles, then north 2 miles instead of taking the direct 1.2-mile route on my road. I didn't feel guilty. I felt vindicated. They'd had 12 years to negotiate fairly. Instead, they'd trespassed, sent security guards to force my gate, sued me, and lost. Now they were living with the consequences. By early October, the financial impact on Riverside Heights was becoming clear. The HOA had to pay me $350,000. The board voted to special assess every homeowner $1,030 to cover the judgment. That bill arrived in mailboxes on October 15th, 2024. The reaction was immediate and furious. David forwarded me a copy of an email chain from the HOA's internal listserv that someone had leaked to the press. From Michael Torres, 4472 Riverside Court. Subject, special assessment, unacceptable. We're being charged $1,030 because Vanessa Whitmore decided to sue a 67-year-old woman over a private road instead of negotiating? This is insane. I'm calling for an emergency meeting to remove the entire board. From Jennifer Pack, 4801 Riverside Drive. We bought our house specifically because of the convenient access to the highway via Thornton Road. Now we're driving 12 miles extra every day and paying $1,030 for a lawsuit we didn't want. This is Vanessa's fault. She needs to go. From David Brennan, 4523 Riverside Court. Our property values are dropping. 3 houses on my street are listed for sale. All of them mention inconvenient access as the reason. Realtors are telling sellers that homes are worth 10 to 15% less now because of the detour. Vanessa destroyed our property values. The property value issue was real. I'd been monitoring real estate listings in Riverside Heights out of curiosity. In September, before the trial, homes were listing for $650,000 to $850,000, depending on size and location. By late October, identical homes were listing for $550,000 to $725,000, a 15% drop. Realtors were explicitly noting the access issue in listings. Beautiful 4-bedroom home in Riverside Heights. Note, primary access route, Thornton Road, currently unavailable. Residents use county road access, adding approximately 25 minutes to highway. Buyer should verify access situation before purchase. The inconvenience was tanking property values, and HOA residents were furious. On October 22nd, someone knocked on my door. I looked through the window and saw Vanessa Whitmore standing on my porch, alone. No attorney, no security guards, just her. I opened the door but didn't invite her in. "Mrs. Thornton, can we talk?" "About what?" "The road, the situation. I think we got off on the wrong foot. You sent 4 men to cut my gate lock with bolt cutters. You sued me for $40 million in damages. You lost and cost your HOA $350,000. I'd say we got off on the worst possible foot." She took a breath. "You're right. I made mistakes. I should have approached this differently from the beginning. But I'm here now to try to fix it." "Fix it how?" "I want to negotiate an easement, something reasonable that works for both of us." I crossed my arms. "I'm listening." "The HOA will pay you $50,000 for a permanent easement giving residents access via Thornton Road. We'll also agree to contribute $2,000 annually toward road maintenance." I almost laughed. $50,000? After 12 years of free use, a lawsuit that cost you $350,000, and property values dropping 15%. You think $50,000 is reasonable? "Mrs. Thornton, the HOA doesn't have unlimited funds. We just paid you $350,000. We can't afford—" "You can't afford it because you wasted money on a lawsuit you had no chance of winning. That's not my problem." "What do you want?" "Before the lawsuit, I was willing to negotiate for $250,000 plus $15,000 annually. You refused. You chose litigation. Now the price has gone up." "To what?" $500,000 for a permanent easement, $20,000 annually for maintenance and the right to use my road, full liability insurance, $2 million coverage, protecting me from any accidents or incidents, and a written apology from you and the HOA board, acknowledging that you trespassed on my property for 12 years without permission." Vanessa's eyes widened. $500,000? That's extortion. "No, it's the cost of disrespecting property rights. You had the opportunity to negotiate fairly. You chose to fight. You lost. Now you pay the premium." "The HOA will never agree to that. We'd have to special assess homeowners another $1,500 each. They're already furious about the first assessment. Then they can continue using the detour. Property values are dropping. People are threatening to sell. This is destroying our community." I kept my voice calm. "Your community was built on the assumption that you could use my private road without permission or compensation. That was always a bad assumption. Now you're facing reality." Vanessa's face flushed red. "You're enjoying this. You're punishing 340 families because you're vindictive. I'm protecting my property rights, the same property rights you ignored for 12 years. We used the road. For 12 years. You never stopped us. I told your developer in 2012 not to use it. He ignored me. I posted signs in March. You ignored them. I gated my road in April. You sent security guards to force it open. I've been trying to stop you from day one. You chose to ignore me. Because you were being unreasonable. I was being a property owner. You were being a trespasser. Now you want me to give you access for a fraction of what it's worth because your residents are upset? That's not how this works." Vanessa took a step closer, her voice dropping. "Mrs. Thornton, I'm trying to be reasonable. I'm here, negotiating in good faith. You're here because your residents are furious and your property values are dropping. This isn't good faith. This is desperation. Fine. What if we do $200,000? That's as high as we can go without another special assessment. $500,000, non-negotiable. That's insane. Then leave." Vanessa stared at me for a long moment, her jaw tight. "You're going to regret this. The HOA will find another way." "Another lawsuit? You're welcome to try. I'll win again, and it'll cost you another $350,000 in fees and damages." She turned and walked back to her car, slamming the door so hard I heard it from my porch. I went back inside and called David. Vanessa just showed up at my door, offered $50,000 for an easement. David laughed. $50,000 after losing a $350,000 judgment? I countered at $500,000 plus annual fees and a written apology. She called me an extortionist. You're not an extortionist. You're a property owner setting terms for use of your property. She can accept or decline. She declined. Said the HOA would find another way. There is no other way. They lost in court. They have no legal right to your road. Their only option is to negotiate on your terms or keep taking the detour. Good. By November, the situation in Riverside Heights had deteriorated further. 7 homes were on the market. 2 had sold, both at significant losses compared to pre-lawsuit prices. The HOA held a special meeting on November 12th to discuss the access crisis. Someone recorded the meeting and sent the audio to a local news station. They aired excerpts. Vanessa's voice. We are exploring all legal and practical options to restore access to Thornton Road. Mrs. Thornton is being unreasonable, but we will find a solution. Resident voice. You caused this. You sued her instead of negotiating. Now we're paying $1,030 each and our property values are tanking. Another resident. My house was worth $680,000 in August. I just got an appraisal for refinancing. $580,000. I've lost $100,000 in equity because you couldn't negotiate with one woman. Vanessa. Mrs. Thornton is demanding $500,000 for an easement. That's extortion. We're not paying it. Third resident. So what's your plan? Keep the detour forever? My commute is an hour longer every day. My wife is looking for jobs closer to home because the drive is unbearable. Vanessa. We're working on it. Fourth resident. You're not working on anything. You're too proud to admit you were wrong. Just pay her the $500,000 and end this. The meeting devolved into shouting. The local news ran a story on November 15th. HOA residents suffer as property dispute drags on. They interviewed several Riverside Heights homeowners. One man, standing in front of his house, "We're prisoners in our own community. Every trip takes an extra 30 minutes. My kids are late to school constantly. My boss is threatening to write me up for tardiness. All because the HOA president was too stubborn to negotiate." A woman. I supported the lawsuit at first. I thought Mrs. Thornton was being unreasonable. But she owns the road. We were using it without permission. We were wrong. The HOA should pay what she's asking and move on. The reporter tried to interview me. I declined. But David gave a statement on my behalf. Mrs. Thornton has been clear from the beginning. This is her private property. She's willing to grant an easement for fair compensation. The HOA's continued refusal to negotiate is their choice. On November 20th, I received a formal offer from the HOA's attorney. $300,000 for permanent easement, $15,000 annually, $2 million liability insurance, no written apology. It was closer, but it wasn't my terms. I responded through David. $500,000, $20,000 annually, $2 million liability insurance, written apology from HOA board acknowledging 12 years of trespassing. All terms non-negotiable. Offer expires December 31st, 2024. Patricia Vance called David. Your client is being vindictive. The apology serves no legal purpose. It's purely to humiliate the board. The apology serves the purpose of acknowledging wrongdoing. The HOA trespassed for 12 years. A written acknowledgement is appropriate. Vanessa will never agree to it. Then the gate stays closed. December came. The detour continued. Property values continued dropping, and Vanessa Whitmore's position as HOA president became increasingly precarious. On December 10th, a petition began circulating among Riverside Heights residents, calling for a special recall election to remove Vanessa and the entire HOA board. It needed signatures from 30% of homeowners, 102 signatures. By December 15th, it had 187 signatures. The recall election was scheduled for January 15th, 2025. Vanessa's reign as HOA president was coming to an end, and my gate remained closed. The recall election took place on January 15th, 2025. I didn't attend. I wasn't an HOA member and had no interest in their internal politics, but David kept me updated. The vote wasn't close. Vanessa Whitmore, recalled by 89% vote, 303 votes to remove, 37 votes to retain. The entire HOA board was removed in the same election. New board members were elected the same night. The new HOA president was Thomas Brennan, a retired engineer who'd lived in Riverside Heights for 8 years. He'd been one of the most vocal critics of Vanessa's handling of the road dispute. On January 17th, 2 days after the election, Thomas called me. "Mrs. Thornton, this is Thomas Brennan. I'm the new president of the Riverside Heights HOA. I'd like to meet with you if you're willing. What do you want to discuss?" "The road, an easement agreement, and an apology." That got my attention. "An apology?" "Yes, ma'am. On behalf of the HOA, I want to apologize for 12 years of trespassing on your property. You told us in 2012 not to use the road. We ignored you. That was wrong. The previous board compounded that wrong by sending security guards to your gate and suing you. That was inexcusable. I'm here to make it right. I'm listening. Can I come to your home tomorrow morning? I'd like to discuss terms in person." I agreed. Thomas arrived at 10 a.m. on January 18th. He was in his late 60s, gray hair, dressed casually in jeans and a flannel shirt. He carried a folder and a box. I invited him onto my porch. We sat in the 2 rocking chairs my grandmother had bought in 1952. "Mrs. Thornton, thank you for seeing me." He opened the folder. "I've reviewed everything. The lawsuit, the court documents, your property records, the correspondence from 2012. You were right about everything. The HOA was wrong. Vanessa was wrong. And I'm here to negotiate an agreement that respects your property rights." "What are you proposing?" $250,000 for a permanent easement granting HOA residents access via Thornton Road. Annual payment of $12,000 for road maintenance and the privilege of using your property. $2 million in liability insurance protecting you from any accidents or incidents on the road. And a formal written apology from the HOA board acknowledging that we trespassed on your property for 12 years without permission or right. He handed me a document. It was a draft easement agreement, professional, detailed, fair, and attached to it was a 1-page letter on HOA letterhead. "Dear Mrs. Thornton, on behalf of the Riverside Heights Homeowners Association, we offer our sincere apology for 12 years of unauthorized use of your private property. In 2012, you explicitly informed our developer that Thornton Road was private, and you would not permit its use for residential traffic. We ignored your wishes and used the road anyway. That was trespassing. In 2024, the previous HOA board escalated the situation by sending security personnel to force open your gate and filing a lawsuit claiming rights we did not have. Both actions were wrong. You have been patient, clear, and legally correct throughout this dispute. We failed to respect your property rights. We are sorry. We hope to move forward with a fair agreement that compensates you appropriately and recognizes that Thornton Road is your private property, generously shared with our community under mutually agreed terms. Respectfully, Thomas Brennan, HOA President, Riverside Heights, HOA Board of Directors." I read it twice. It was exactly what I'd asked for. Acknowledgement, apology, respect. "Mr. Brennan, this is a fair offer, but my position was $500,000, not $250,000. Thomas nodded. "I understand. And frankly, if Vanessa were still president, I'd tell you to hold firm at $500,000, because she deserved to pay the premium. But Mrs. Thornton, our residents are suffering. They've already paid $1,030 each to cover the judgment against us. Property values have dropped 15%. 7 families have sold at losses and moved away. The 12-mile detour is destroying quality of life." He leaned forward. "I'm not asking you to accept less because we deserve a discount. I'm asking because our residents, most of whom had nothing to do with Vanessa's decisions, are being punished for mistakes they didn't make. If you can accept $250,000, we can pass this agreement without another special assessment. If you hold at $500,000, we'll have to charge residents another $735 each. Some families can't afford that. They'll be forced to sell. I considered this. I'd never wanted to hurt the residents. I'd wanted to protect my property rights and force the HOA to respect them. The new board was offering respect, acknowledgement, fair compensation, and an apology. "Mr. Brennan, what happened to Vanessa?" His expression darkened. "She resigned the day after the recall vote. She and her husband listed their house for sale on January 20th. They're moving to Arizona, but that's not the end of her problems. What do you mean? 17 homeowners have filed personal lawsuits against her for mismanagement, breach of fiduciary duty, and wasting HOA resources on an unwinnable lawsuit. They're seeking damages for the property value losses and the special assessments. Her attorney thinks she's facing $200,000 to $300,000 in personal liability. Will she pay it? She'll have to. Her homeowner's insurance won't cover it. Board decisions made in bad faith aren't covered. She's on the hook personally. I heard she and her husband are selling their Riverside Heights house at a $90,000 loss, just to get out fast and start over somewhere else. I thought about Vanessa standing on my porch, offering $50,000 and calling me an extortionist. She'd lost everything, her position, her reputation, her home, and now she faced personal lawsuits that would cost her hundreds of thousands of dollars, all because she'd refused to respect property rights. Mr. Brennan, I'll accept your offer. $250,000, $12,000 annually, $2 million liability insurance, and the written apology. On one condition. What's that? The road maintenance is entirely the HOA's responsibility. I've maintained it for 101 years. I'm done. You repave, patch potholes, clear snow, trim trees, all of it. If the road deteriorates under HOA use, you fix it at your expense. Agreed. We'll add that to the contract. Then we have a deal. Thomas smiled, the first genuine smile I'd seen from anyone connected to the HOA in 9 months. Thank you, Mrs. Thornton. I'll have our attorney draft the final agreement. We can close in 2 weeks. He stood, then reached for the box he'd brought. I almost forgot. This is for you, from the residents. A thank you for being willing to work with the new board. He handed me the box. Inside was a beautiful hand-carved wooden sign. Oak, professionally made. Engraved text read, Thornton Road, private property, a stand at 1923, shared with Riverside Heights community by agreement. We thought this might be a better sign than no trespassing, Thomas said. It acknowledges the history and the agreement. I ran my fingers over the carved letters. It was beautiful. Thank you, Mr. Brennan. This is thoughtful. It's the least we can do. The agreement was finalized on February 3rd, 2025. The HOA paid me $250,000 in a lump sum. The easement agreement was recorded with Douglas County. The gate at the entrance to my property was removed, and the new sign was installed in its place. On February 5th, Thornton Road reopened to HOA residents. I sat on my porch that morning and watched the first vehicles drive past. Parents taking kids to school, commuters heading to work, all of them using the direct route again. No more 12-mile detour. A few drivers slowed as they passed my house. Some waved. One woman stopped and rolled down her window. Mrs. Thornton? Yes? I'm Rachel Kim. I live on Riverside Court. I just wanted to say thank you for working with the new board. The detour was killing us. We appreciate you being willing to compromise. It was never about hurting residents, Ms. Kim. It was about respect for property rights. I understand, and I'm sorry for what Vanessa put you through. Most of us didn't support the lawsuit. We just didn't have a voice. You have a voice now. Use it. She smiled and drove on. That afternoon, David called. Maggie, I just heard from Patricia Vance. Vanessa's house sold. She and her husband are moving to Scottsdale next week. How much did they lose? Listed at $680,000. Sold for $590,000. Plus they're paying legal fees for the personal lawsuits. Total loss is probably close to $150,000 after everything. And the lawsuits? Still pending, but her attorney is negotiating settlements. She'll probably pay out $100,000 to $150,000 total to make them go away. I thought about Vanessa's face when Judge Brennan ruled against her. The shock, the disbelief. She'd thought she could bully a 67-year-old woman into surrendering property rights. She'd been wrong, and it had cost her everything. David, send a final invoice for your services. Let's close this chapter. Already done. And Maggie, this was a good case. You stood your ground. You defended property rights, and you won. We won. I hung up and walked down to the new sign at the entrance to my property. Thornton Road, private property, EST'd at 1923, shared with Riverside Heights community by agreement. It was perfect. The road was still mine, but it was shared now, on my terms, with my compensation, and with respect for my ownership. That's all I'd ever wanted, respect.